In an extremely crucial verdict from the top court of the country, the Supreme Court of India has today upheld the 103rd constitutional amendment, which provides for a 10% quota for the economically weaker section. A five-judge constitution bench by a 3:2 majority has today upheld the amendment, which basically means that while three judges decided in favor of the amendment, two judges in their minority opinion decided against it. The majority opinion was given by Justice Dinesh Maheshwari, Justice Bela Trivedi and Justice J.B. Pardiwala, and the minority opinion was given by the Chief Justice of India, Lalit and Justice Ravindra Bhat. Before we move on to what the judges had to say and the reasons given by them, let's first take a quick look at what the amendment actually says. The 103rd Amendment was brought into the Constitution back in January 2019 by the government, and it provides for a 10% quota for the economically weaker sections. What's important here is that the 10% quota is over and above the 50% reservation which has already been granted to the socially and educationally backward classes, which includes the SCs, STs and the OBCs. The other thing is that the backward classes, being the SC, STs and OBCs, are in fact excluded from the 10% EWS quota. Moving on to what the judges had to say. The majority opinion given by the three judges had dealt with three aspects related to the quota. First of all, exclusion of the backward classes from the 10% quota. Secondly, the 10% quota being over and above the 50% ceiling limit on the reservations already been granted to the backward classes. And also, third aspect being whether economic criteria can be the sole criteria to decide on whether reservation is to be given to a particular class. According to the majority opinion, in all three aspects do not violate the basic structure of the Constitution, do not violate the Equality Code and are not discriminatory. According to the majority opinion given by the three judges, the state has the power to take affirmative action for not just the backward classes but also for any other disadvantaged class. Now moving on to the minority opinion given by the CJI and Justice Ravindra Bhat, which has said that economic criteria, being the criteria for reservation, is per se not violative of the Constitution. However, they have struck down the amendment on the basis of exclusion of the socially and educationally backward classes from the category. According to them, such exclusion is not only discriminatory, it's violative of the Equality Code, the principles of non-discrimination and non-inclusion, which form an extremely crucial part of the basic structure of the Constitution. Considering that three judges, majority of the judges, have agreed with upholding the constitutional amendment, the 103rd Amendment continues to remain valid, and so does the EWS quota. With camera person Ankit from New Delhi, this is Srishti Ojha, India Today.